Among the few topics which are very, very important for mains, constitutional morality is one such topic which is extremely important. You must have often heard about this constitutional morality in various debates. What exactly do we mean when we say constitutional morality? Now we have to just trace back to the idea of constitutional morality, which goes to Crote, and he was a Greek thinker. He basically said that according to him, the constitutional morality means paramount reverence to the forms of constitution, means paramount reverence, means respect, worship. So paramount, that is the key word, paramount reverence to the forms of constitution. Now this can be slightly confusing. What do we mean by paramount reverence to the forms of constitution? So the key word is forms of the constitution. Another means, I'll come to this, and he also said the other aspects which he said about constitutional morality is, he meant that idea of free speech and self-restraint. And according to him, constitutional morality is must for governance which creates peaceable conditions, for, we can say, for peaceful, harmonious existence of society, you need to have constitutional morality. The government of the day, the rulers of the day, they have to follow the constitutional morality. Now, what do we mean by paramount reverence to the forms of constitution? Now, constitution has certain ideas which are explicitly stated. Explicit ideas are there mentioned in the constitution. Then there is something called the spirit of constitution. Like for in this Sabrimala judgment, the Supreme Court also mentioned about constitutional morality, and it linked it with the idea of equality and non-discrimination. Now, part of it we have understood that by constitutional morality, we would mean that whatever is there in our constitution, whatever is mentioned in our constitution, and even those things which are not explicitly mentioned but are embedded in the spirit of the constitution, have to be followed. For example, equality, non-discrimination, free speech, liberty, so many other things can be there, like untouchability. The spirit of the constitution, it will be amounting to not upholding the constitutional morality. Now let me further explain. Like in this regard, we also need to look at what Dicey said. He is another important political thinker. He said that there are certain laws, statutes. I am explaining the essence of what he said. I am explaining in my own language what he meant. So laws and statutes can be enforced in the court of law. So the constitution is enforceable in the court of law. But the conventions of the constitution may not be enforceable, but they are to be followed. For example, after a general election, which party is to be invited or who is to be invited to form the government? When the government holding majority, can it be dissolved? Can the governor or president dissolve against the advice of the Council of Ministers the government which holds majority in the popular house? So these are the conventions which are not very clearly mentioned in the constitution, but the convention is that there are certain well defined, well understood norms which have evolved over the years, and we follow it without explicitly mentioning in the constitution. So they are the constitutional convention. So one is the form of the constitution, another is the spirit of the constitution, then there are constitutional conventions. So we can say, so we have to have, this is what Grote said, he paramount reference to the forms of constitution. So in this, let us add the explicit provision, the spirit of the constitution, and also the conventions. Now when we look at our constitution, let us further try to understand in terms of the constitution. Now when we have our constitution, we have institutional arrangement. There are various institutional arrangements. Take for example the most relevant, UPSC or State Public Service Commission. Let me take one more example, Election Commission of India. Let me take one more example, say the Commission for Article 338, that is for scheduled caste, Commission for protecting the interest of scheduled caste. So these are the institutional arrangements. Now these institutional arrangements will not function in isolation. Now what is the purpose of UPSC or State Public Service Commission? It is an institution created by the Constitution and with certain powers and limitations. Now limitations may not be explicitly stated, but these are implicitly understood, means which is not mentioned but which is part of the Constitution. Now limitation is that UPSC will conduct, the power is the UPSC has powers to recruit and suggest, they advise the government about the recruitment measures and all, also to conduct the examination, etc. And the limitation will be that all the process have to be transparent and fair, because it is not required to be mentioned, but it's a limitation. Every authority created by a constitution, constitutional governance and constitutional morality per se means limitation. So there are limitations on each institution, how that institution will function. For example, Election Commission of India. It is an institution for conducting elections. But there it is not required to mention that it will conduct election free and fair manner. It is understood that election has to be conducted in free and fair manner. That's part of the overall constitutional design. Equality, right to equality. Then the provisions which are there for electoral roll, for registration of voters, and also overall the scheme means that the thing has to be transparent, fair, and upholding the democratic norms. So one is the institutional arrangement, and another is the constitutional provisions. So when the institutions function according to the constitutional provisions which are specifically mentioned, and also according to the spirit of the Constitution, and also according to the conventions of the Constitution, we can very well hold that we are following the constitutional morality. Now in this regard, there is something very interesting which was said by Dr. Ambedkar while making a speech in the Constituent Assembly, and he was basically justifying that why our constitution contains so much of administrative detail. Take for example, UPSC is an additional administrative detail which may not be available in many other constitutions, which is something which is expected, that recruitment has to be fair and there has to be a body. Election Commission is also an institution which is specially created by the Constitution. This is some kind of an administrative detail. The Commission under Article 338, 338A, 338B, all these are basically created by Constitution for certain purpose, which even if they were not created, it was expected that such institutions would have come into force by statute or by law, keeping in view the spirit of the Constitution. But certain administrative details were kept in the Constitution, and that is why our Constitution became lengthy. And Dr. Ambedkar very nicely justified that by saying that you can pervert the Constitution by changing the form of administration. Let me explain it. So there is something called administration, which we all know. One is constitution. Now we have form of administration. This administration or the administrative arrangement which will be created, suppose it is not mentioned in the constitution. Constitution gives the general principles, general details, and based on that we make laws and create the form of administration in various institutions. Now this form of administration is expected to follow the constitutional limits, spirit, the explicit, implicit provisions of the constitution, the conventions, age-old conventions of democracy, democratic system of governance. Now, if the form of administration is designed such that it is not fulfilling the constitutional objectives, you are effectively changing the form of constitution, we are perverting the constitution by changing the form of administration. But if the form of administration is umbilically linked, is linked to the constitution, means the form of administration is explained or mentioned and described and limited in the constitution itself, you can't pervert the constitution. So Dr. Ambedkar gave that reason that why we have so many details in our constitution is he said that you can easily pervert the constitution by changing the form of administration, but if the form of administration is there in the constitution itself, it will not be easy to pervert or change the constitutional arrangement. By constitutional morality, Dr. Ambedkar also meant, he also, in fact, in his speech, he also quoted Grote and he also quoted this paramount reference to the forms of constitution. And he also said that democracy in India is a top dressing on Indian soil because it's a foreign concept. So we are yet to diffuse the constitutional values amongst the administration and the political class. For that, we need to hold fast to the constitutional provisions. Unless there is so much of diffusion, means if the psyche of the nation becomes such that there is reverence, respect, and paramount dedication to the democratic norms and values, then I think the constitutional provisions, whether they are there or not, doesn't make much difference. But till such time that diffusion of the constitutional morality takes place, we need to have safeguard and such systems embedded in the constitution so that whatever we design reaches out to the people. Constitution meets its objectives and it is able to fulfill the designed aspirations or the desires which our freedom fighters and the Constituent Assembly had. This is broadly what constitutional morality is. You can refer to the books for greater detail, because while explaining many things which I have might have missed out because I'm not carrying any paper or reference with me, I'm covering this topic in good detail in my upcoming book.